involved in the next case come forward, and excuse you all from the first case to go about your day. Thank you. A couple of times. I had one going over here, too. All right, while you all are settling in, we'll call the case. This case is Dahl versus Dahl, appeal number 20240740. Can I have the attorneys who are going to be making appearances today please do so for the record?
Good morning, Your Honor. Steve Christensen for Kim Dahl, here with Clinton Brimhall.
Good morning.
Rosamund Blakelock, Your Honor, on behalf of Dr. Charles Dahl and Megan Blakelock.
Morning to you as well. Okay, have you guys had a chance to chat about time reserved for rebuttal? Mr. Christensen?
No, but I'll take 5 minutes.
Okay, lovely. And you all have been here before a number of times, so unless you all have any questions about the procedure today, we'll turn the time over to you, and we look forward to hearing from you with regard to your arguments. Mr. Christensen.
Thank you, Your Honor. Your Honor's counsel, may it please the court, Kim Dahl is here appealing the order coming from the remand from the Supreme Court. In the order in Dahl versus Dahl, the Supreme Court stated that Charles crafted a trust agreement purporting to eliminate any interest Mrs. Dahl had in the trust property upon the couple's divorce. Finding that was inequitable, the court issued a remedy and directed the district court to determine what property contained in the trust was properly characterized as marital property. Kim is here objecting and appealing the decision of the trial court to do something different than what the Supreme Court mandated. In essence, the district court determined that identifying the marital portion of the trust was too hard, and determined that that was too hard because the property had been commingled. Therefore, the court did not identify the marital property.
And when the court was talking about, when the court said used the word commingling in that context, my understanding the court was talking about commingling of trust property with other property that the parties had.
I think it was, at least the claim was that trust property was commingled with premarital property that Charles had, and then I believe the claim was that he had also commingled the trust property with property he earned after the divorce. So I think it was a commingling of separate versus marital property.
But wasn't there always separate property in the trust, as well as what the Supreme Court said could potentially be marital property?
Yes, so there was. I think that one of the original assets in the trust was premarital assets. Some of the issues we raised on appeal was the actual tracing of those assets, because there was testimony that some was liquidated and it was put in cash and it was all kept together as cash. And so tracing that premarital portion, I think, is one issue. But I think the unraveling question is the one that the court got stumped on in terms of whether it's too difficult for the court to identify marital property, which seemed like it was because trust property had been actually removed from the trust, put into another vehicle. Marlette was the name of the vehicle in the trust. It was moved to another vehicle called Savoy. And that also had money that had been earned after the divorce in it. And I think that problem was one of the difficulties the court had. So our argument to that is that the court should at least have allowed discovery to occur in order to identify what went into that vehicle, what went out of that vehicle, find where that property went, and if in fact it was commingled, then to follow Dunn versus Dunn and require Charles to trace the property that he claimed to be separate property and identify that.
Yeah, see, now I'm getting confused again between commingling of his separate property into the trust and commingling of the trust assets themselves that were, had a corpus as of the date the decree was signed, right?
Right.
We know what was in there.
Yep, we did.
And the problem, I think the district, as I understood it, that the district court was identifying was after that date, that the trust corpus got commingled with other things in the years to follow.
Yes.
So there are two different issues of commingling, and for me anyway, I think it's important to sort of, disentangle those. That's why I'm asking.
Yes, I agree with you. So maybe we could just say that, let's assume that $350,000 of separate property started in the trust before the parties even filed for divorce, just as a rough estimate. And then $1 million+ were poured into the trust that were marital property. That was, something along those lines was the corpus at the time of the divorce.
Mm-hmm.
And
everybody knows what that number is. There doesn't seem to be a dispute about that.
I don't think that's the dispute.
Yeah, the dispute seemed to me to be, well, what to do next?
Exactly. So, there became a little bit of a dispute between $350,000 and $1 million to $2 million in terms of whether assets were being moved around in the trust, liquidated, and somehow mixed up together. But I think the bigger issue is what happened to the funds after the divorce. Where did the corpus go? And I think that is what the court is referring to when it says that it was commingled, because I think that the funds of the trust were taken out of the trust and placed into other vehicles.
But doesn't that only matter if you're valuing the trust at a date other than the date of the divorce?
Well, I think that in order to, one of the solutions of the court was to ask that question, but I don't believe that that was the directive of the Supreme Court.
Well, I'm looking at the decision from the Supreme Court in paragraph 212, and it doesn't say one way or the other. It says Ms. Dahl is entitled to withdraw her share of the marital property she contributed to the trust as a settler. So the answer to that question is, what was her share of the marital property that was in the trust, right? That's a question.
That's the question.
And then it says, on remand, the district court should determine what property contained in the trust is properly characterized as marital property, and that's in order to allow Ms. Dahl to withdraw,
Correct.
right?
Yep.
And then it says, and either credit Ms. Dahl with an offset equal to the value, or allow her to take the property out. So once you know what the property is, there are two options. She can get an offset of value, or she can take the property itself.
Correct.
That seems clear to me, but does not in any way reference dates, times, or when anything should occur. So the district court didn't have any guidance from this paragraph itself to say you're doing that in 2023, which is 8 years after this opinion, or you're doing it at the time of the divorce when the property is identified as the trust.
Well,
Right, so it seems to me that we don't have a clear directive from the Supreme Court as to when to do it. And if you think there's language in here that says, that makes it clear, I'd love to see it.
I don't have any different language than that. I think that 212 is the directive of the Supreme Court. But my read of it is that when the court says, determine what property contained in the trust is properly characterized as marital property, that is directing the district court to identify the trust property. It's not saying go
But as of
estimate.
when?
I think, I
The
mean, as
Supreme
of,
Court doesn't say, right?
doesn't say, but I mean, at least as of 2015, when the court gave that direction. I mean,
Why? Why though? Why wouldn't it be the date of the divorce?
because this is, I mean, essentially what we have is a trust asset where the Supreme Court is determining that Kim is, she's not a beneficiary of the trust. She is essentially a settler of the trust, and this is her property. The Supreme Court is saying treat her as a settlor essentially, and identify her property, and let her receive her property back.
And she was supposed to have received it way back in 2010, right?
Correct.
Yeah.
Correct.
So the district court's whole locution of thinking of this as sort of thinking of her as a creditor, you take issue with in your brief, but it sounds like if, you know, the trust has X amount in it as of 2010, and the Supreme Court's directive is she's entitled to half of the marital property in the trust as of 2010, then why is the district court wrong to think of her as a kind of a creditor at that point?
Because she's not a creditor, she is a settlor. She's an owner of that property, and she's entitled to the growth of that asset. Whether it's in 2010 or some other date, she's entitled to the actual replacement value, the growth of that asset. And so our argument is that, first of all, the court had absolutely no evidence at trial about any other valuation method than the one that was proposed by the two experts of the parties. Both of those agreed to the valuation method is a market replacement method. None of them came and said, this is the type of situation where we treat you like a creditor, or that simple interest is the right value. Both said market replacement. One said it's closer to an 8% return. One said it's closer to an 11% return, but both used the same analysis. The only reason they had a different value is one used equities as the benchmark and one used government securities as a benchmark, and they produced a lower return over time.
There's language in paragraph 212 that I think is your best argument, and I've not heard you point to it. So I'd like to point to it and
Okay.
get your take on it. This is a forward-looking remand, and the Supreme Court says that Ms. Dahl could withdraw her share of the property sometime after remand, or on remand or thereafter. That would imply that the Supreme Court is saying Ms. Dahl is allowed to withdraw her property, not back in 2010, but after remand, which implies that the court is looking at the property either going to her or the value of that property after remand going to her. To me, that seems like your best argument out of paragraph 212.
I agree.
Do you have a comment? Is that your best argument?
I agree, it is. I mean, I think the Supreme Court is treating this as a trust. The Supreme Court is expecting that this trust is being held essentially in a fiduciary type status. I mean, Charles came to the court essentially telling the court that this is a trust that should operate under trust principles. Therefore, the property should be maintained and should be accounted for. And any withdrawal of property from the trust should have followed trust principles. I think that the Supreme Court is assuming that that property is available and it would be returned to Ms. Dahl. And that's our request, is that the court determined that the court should have identified that property and returned it to her. And if that property is not there, the court should determine where that property went and return that to her from the location where it went to. So,
But doesn't that begin with an evaluation of what was there in 2010? Because the share that was hers was there in 2010, and the Supreme Court is saying back in 2010 is when this should have been identified as hers, and she should have been able to withdraw it or, you know, do whatever she wished with it because it was hers. So don't you have to look at 2010 to say what was there and therefore what was hers?
well, I don't think the Supreme Court said that, but I do think that there is a marital property component. And marital property was defined as of 210. And after 210, whatever money was generated either was an appreciation of marital property or it was not marital property. So I do think 210 has a relevant place, but I don't think that the Supreme Court is cutting off the analysis at 210 and saying, you must value this at 210. I think that the Supreme Court's basically saying, identify the marital property. And I think, let's go identify what is in the trust and what happened to that property after that. Did it grow? Did it sit in the trust and just grow? And we can just go say, okay, it was 100 shares of GM and now it's split 3 times and it's 400 shares of GM. That's the simple case. Or did it go somewhere? And let's go find it and let's bring it back and give that to Ms. Dahl.
I have a question about discovery.
Yes.
In the court's ruling and order regarding property distribution that it made on remand, it says the court found that, speaking of its prior finding, that Dr. Dahl produced in discovery all the documentation that he possessed that was relevant to the proceedings. And in your briefing on appeal, the only place where I see you challenge that finding is on page 28 of your brief, where you say Fidelity did not disclose everything it had, nor did Charles. And then you cite to a page of a memorandum in the record. I'm not sure that you've adequately challenged the finding that Dr. Dahl produced in discovery all documentation that he possessed that was relevant to the proceedings. Why should we not just accept that finding and say, if he's produced everything that's relevant, the district court did not abuse its discretion by not allowing more discovery?
Well, what we do challenge is his reasoning, because basically he says that he has produced everything that is relevant to the proceeding in light of the judge's determination that the property will be valued in 2010. And so we do brief that issue that once the court determines that determining the valuation in 2010 is not the correct approach, but rather that we should determine from 2010 where the property went and what is that property today, then the discovery question is different. So we called that out to the court in our brief, but the proceedings that led to this trial were that the judge basically refused to compel the discovery response that we had made a motion for, and said that we will hold a 2-day trial first, and then I will decide whether to compel that information or not. And he decided not to compel it because he's just going to fix that value at 2010.
So you're saying that the court's use of the term relevant there is not relevant to everything that's been raised in the proceeding, but that the court is only saying, as I'm viewing this proceeding, it's relevant.
Which, in our reply brief on page 10, under Roman numeral 4, we go through that process to say, as the court defines it, that this is all he needs. I'll reserve the rest.
Couple more questions, really
go ahead.
quick. On the argument about the $356,000 of separate property that was put into the trust originally.
Right.
You're not contesting, as I understand, I just want to get a sense of the scope of your challenge here. You're not contesting that that was in fact separate property in the beginning. When it was put in.
When it was put in, we agree it was separate property.
And you're not contesting the finding the court did make on this, which was Dr. Dahl did not have any intent to commingle it.
No, we're just saying.
You're just saying there's a second piece to this, traceability, that the court didn't make any findings on, and so you're saying, please remand for findings so the court can look at traceability of this.
Correct.
That's it.
Right.
Okay.
I mean, in terms of the 356.
Yeah,
that's
and
it.
on dissipation, the $92,000, I just want to get my mind around this one. This, as I understand the other side's argument on this one came up for the first time in your written closing argument. where you listed three things in a little table in your written closing argument that you thought constituted dissipation. The response from the other side is, well, there was no testimony about this. This came out of nowhere. There's no evidence to support any of this in terms of the testimony. This wasn't really an issue during the case. So that's why the court didn't act on it. And I'd like your response to that.
So I believe Charles testified to this at trial, and we went through, essentially, I mean, there's this huge diagram of what came into the trust, what went out of the trust, where did it go, and to the extent that we had discovery, we described that, and he admitted to money in the trust before 2010, leaving and going to a few accounts. That was in testimony, and in our brief and in our request for an amended findings, we point out to the court there was this testimony, and it totaled $92,000. The court didn't address it. It didn't say one way or another.
In your brief, you don't point us to that testimony. Are you able to point us to that testimony now? I mean, in your brief, you point us to your written closing argument. The written closing argument, understandably, there probably weren't transcripts ready to point to pages. But are you able now to point us to that evidence?
Can you let me do that on my reply?
Sure.
Okay, thank you.
Okay, thank you, Mr. Christian.
I've got a couple of other
Go ahead.
questions.
Yeah.
On the premarital property and whether there was commingling, you do point us in your briefing to some testimony where Dr. Dahl acknowledges that some stocks were sold, converted to cash, and that cash was just put in with other cash in the trust. And that does, in my mind, raise an issue of traceability,
Right.
or whether it's no longer traceable and commingled. You haven't pointed us to evidence to show that it isn't traceable, and the other side hasn't pointed us to evidence that it is traceable. I'm wondering who has the burden at that point? If separate property is sold, converted to cash, dumped in an account, at that point, who's got the burden? Do you have the burden to show that it just cannot be traced, or does the other side have the burden to show that it can be traced?
I believe that under Burt, Mortensen, and Dunn, there is a presumption that marital property exists in a situation where it's admitted that marital property is sitting in the account. So under Dunn, where the court found that it may lose its separate property distinction, I believe the burden is on Charles to trace it and show that it has not lost its separate property distinction because of that presumption.
And you're pointing to those three cases in Burt, Mortensen, and Dunn.
Yes.
I have a question on the Pheasant Run issue. You have pointed us to evidence, some testimony, and some checks about trust property being used to pay expenses on Pheasant Run. From my review of what you've pointed us to and looking at what checks could be found in the record, they all predated the divorce. Do you have any evidence of trust property being used to pay mortgages or expenses on Pheasant Run after 2010?
Well, I believe that 2010 became the benchmark for the court in terms of what evidence could be produced and could be discovered. I mean, essentially, the reason we were bringing a motion to compel discovery was because Charles gave us an abundance of production up to 2010, but refused to give us production afterwards. So our ability to produce that was hampered by the production of discovery, and all of these accounts are in his control. But I think we're still arguing that even a payment of money from the trust before the divorce was also an indication that this was not his separate property, which is how the trial court treated it.
What was not his separate property?
All of the payments for mortgage and et cetera of Pheasant Run, the court treated as his separate property. But even if it happened before 2010, when it came out of the trust, when it came out of marital assets,
But
That,
before 2010, maybe I'm thinking about it wrong, but before 2010, it's marital property and you're using marital funds to pay for it. That's all fine and there doesn't need to be any reimbursement.
Correct.
So if the trust is being used prior to 2010 to make mortgage payments on Pheasant Run,
it should be marital.
it should be marital and there's no need to reimburse anybody for that.
Correct.
And you've not put on evidence of payments after 2010 where the trust was used to pay Pheasant Run mortgages?
No, I think,
And so that all really comes back to the discovery issue.
yes.
And maybe that's my last question. Was there any were you given any documents for the time period after 2010?
Yes. There was a period of a couple of years where there was basically a special master that was receiving information from Charles voluntarily, essentially, about assets that, and the movement of monies, even up till 2018, I believe. But it was not a complete disclosure of all of the movement of the money from the trust.
And was that disclosed to you directly, or you only received it because the special master received it? Like,
Yeah.
did you get any responses to your discovery?
We got direct responses up to 2010. We got more responses through the special master.
Okay.
Thank you.
Thank you, Mr. Christensen. Ms. Blakelock, your turn.
May it please the court, Rosamund Blakelock representing appellee Dr. Charles Dahl. I would like to go over, when I address the court, some of our concerns about the brief, but to address first some of the questions that were asked of Mr. Christensen and for clarification. The ruling of the court, record number 6249 at paragraph, at the page 7, states that the Judge Lund relied on paragraph 131 of the Supreme Court decision. So that's the answer in regard to what paragraph was relied upon. And if you look at paragraph 131 of the Supreme Court decision, it states that in that, let me find it here. But the judge's decision in his ruling, I think it's at page 5, states, consistent with the Supreme Court's admonition, the court determined to the extent possible it would value the trust assets at the date of the divorce. Paragraph 131, and paragraph 131 states that the overall aim is to achieve a fair, just, and equitable result. It cites to Noble, before the district court can undertake distribution, it must determine the value of the assets. It cites to Stonehocker, and it's well settled. Assets should be valued at the time of the decree of divorce. Cites to Dunn, and on review, the court's factual findings to the value assets will not be disturbed unless it's erroneous. So
The court did say that kind of in a different context, though, than it's holding about the trust. And it's stating a general principle there that that is the default. And the case law does say that a trial court can go with a different date if there's reason to. I'm curious to your response to paragraph 212, that the Supreme Court indicated that Ms. Dahl ought to be able to simply withdraw her share of the property after remand.
yeah, sure.
And how does that not indicate that she ought to be entitled to her property after the remand, and therefore, by implication, the value of her property after the remand?
The court, when it issued its ruling in 2015, I think it was January, I don't think it anticipated in 2026 we would be having that argument. When the court made that explanation, that 212 is a conclusory paragraph. After the whole decision was made, it says conclusion, and then it is explaining about its position on the trust. Where the detail of that explanation, I believe, is at paragraph 38, of the decision when it states that because Mrs. Dahl's a settler of the trust, as Mr. Christensen stated, she may revoke that portion of the trust with either separate or marital property. And then they cite, the Supreme Court cites 275-5-605. In that decision, I think the burden was on Mrs. Dahl, and we argued that, to then, when it was remanded back, revoke her, because it was revocable. She can revoke it. She never did that. In fact, the case set, as we know, for years, didn't do anything. And then when finally it came to trial in 2023, that's when the question came up, well, when, with valuation, and the valuation burden was then conflated or intertwined with the arguments on discovery. And so Mrs. Dahl, number one, did not revoke, never did, even to this day. The hearing was held and it was distributed, but she never went through the process as described in great detail by the Supreme Court. They said you must revoke your interest, you get your property back, whatever it was, and they described the method. In the conclusion, it's paraphrased and stated, but that process that she had the burden to do was never initiated or started. So then the question becomes very confused then when you get to when you value and when you don't. The judge decided at the trial court it should take the sort of the guidance, and I think that's what the judge said in his ruling, take the guidance of the Supreme Court and valued it at 210 when the divorce happened. But then the argument is, well, we didn't get all the discovery, so we couldn't value it at the time of the trial. That's simply not true. Their exhibit.
I want to go back
Okay,
to
I'm sorry,
my other
apologize.
question. At trial, the experts, as I understand it, put on evidence based on the assumption that the parties were trying to determine a proxy for present value of the trust in light of the fact that the documents couldn't show the actual value. The experts would put on methods to approximate the actual current value. Isn't that the approach that both sides took at trial? Well,
that's a complicated, the answer is more complex than that. There was no special master. There was an expert that was hired, Ide Bailey. They were to value the trust and get all the documents. They issued a report that in 2018.
I'm not asking though about that. I'm asking about the experts. Didn't both experts put on evidence of here's the interest rate that I would apply and whether I'd compound it or not to,
Yes.
to arrive at a proxy number for the present value of the trust?
The experts did opine and testify as to interest rates. The judge in his opinion said that because he didn't accept the testimony of either expert, he set forth his interest rate and set forth explanations in his finding, specifically at pages 6 and 7, on why he chose the interest rate he did. When he did that in the appellant's brief, she never addressed, I think he cited 15 cases and 3 statutes, why he based the interest rate when he did. None of those cases, none of those statutes were cited or discussed by the appellant. Nothing.
Well, I kind of tend to agree with you that if the trial court was correct in its valuate, that we're going to be able to value it as of 2010, then maybe that is the interest rate that applies. But if the trial court was wrong about going with the 2010 value and then just applying a judgment interest rate, and instead that there was an implied mandate to value the trust as of its value post-remand, that the approach taken by the experts was the proper approach. And the experts varied as to the number that they would land on, but they agreed, and by putting on the experts, it seems like the parties agreed, at least at the time of trial on remand, that the proper approach was to try to value the trust as of its current value.
That's correct, but the problem with that analysis and the issue the judge was presented with was that the argument presented at trial is that Mrs. Dahl is entitled to the present day value, but Mrs. Dahl expert didn't testify, didn't present a report, and didn't opine on the present value, even though that evidence was available and had been provided. Dr. Dahl had at numerous times, and it's in the court record, a number of times, not only complied with every single request for discovery, but the record's replete with the number of times the court found that. The court found that he did it at the hearing. That's 4719. The court found it in the oral arguments. The court found it at the May hearing. Dr. Dahl produced all that he had. Dr. Dahl also produced information to Ide Bailey, which was in its entirety sent to both counsel, so they had everything in that manner.
Did Dr. Dahl produce to the opposing party documents after 2010?
Extensive, tens and thousands of documents. And I would refer the court to the number of times that in our brief that we note those. He also, and I cited in my brief the number of times Dr. Dahl, and it's in the brief, supplemental productions up to and including current. The discovery didn't stop in 2010. Mr. Christensen had tens of thousands of documents. He produced exhibit number 23, which valued wasn't used or opined on, but he produced it. He didn't cite it in his brief, but they gave it to the judge, and then it just sat there without any expert discussing it. The respondent's exhibit 23 was the Ide Bailey report, which valued the trust as of 2018 or 19. So it was valued, and all the current information, every current bank statement, every current statement of every kind was produced. And the judge found that numerous times in his ruling, in his order, in his oral arguments order. He produced, and not only that, but the respondent also got documents directly from the holder of the documents. It was Fidelity. Thousands of documents directly from Fidelity went to Mr. Christensen, and they were all current. Mr. Christensen's discovery and went up to and including was current.
I think your answer is adequate to my question. I can see that. Could I follow up on the question I asked opposing counsel about in commingling of the separate property? There was testimony at trial by Dr. Dahl that some of the stock was sold, converted to cash, and that cash was put in an account with other cash. And then it seems that at that point there is a question of, can you trace the separate cash? Whose burden is it at that point?
The case law on that, Your Honor, states that first there has to be proof that, an allegation. I think it's Olican that discussed that. But Kim Dahl didn't meet her initial obligation on that. Although they argued that there was commingling, and they argued it to the judge, in the brief, counsel cites to his oral arguments as preserving the issue. And if the court would look at the oral arguments, the documents that constitute the oral arguments, in the oral arguments, they would have preserved the issue had he cited to case law or the evidentiary hearing or the evidence or the facts. But the oral arguments are at 5941 to 5953.
Preserving what issue? I guess I'm confused about whether we have a preservation problem here where the trial court actually did make a ruling on this. The trial court ruled that this was separate property. There'd been no intent to commingle. The court actually fussed with the commingling question.
Yes,
So
Dr. Dahl
what-
testified, I'm sorry.
What obligation do you think the other side had to do more here to preserve something?
Well, Dr. Dahl testified, and there is testimony about it, although not cited in the appellant brief. But if you're talking about the commingling of his $353,000, is that the specific question? Okay, I misunderstood that with the later commingling issue, because there's two. But on that commingling issue, that can be, Exhibit 3 is Dr. Dahl's specific summary of his separate funds. And Exhibit 4 is the proof or the verification that he kept his funds separate in the amount of 350-some thousand, I think it is, and he testified as well. So his exhibits 3 and 4 are cited in my brief.
So
And
are you arguing or are you not arguing that that the other side has a preservation problem with regard to their argument on the separateness, traceability of, commingling of the 356,000?
I did argue that, and I cited they referred in their preservation to their oral arguments, and they can preserve it through oral arguments, I suppose, if they follow the requirements to cite to the case law, show to the judge what happened, that didn't happen.
Maybe I'm not asking a very good question, so let me try again. It seems the preservation law that we have indicates that if the trial court actually rules on something, then we don't have a preservation problem. The whole point of preservation is to make sure that the trial court has an opportunity to rule on something. And here, where the trial court did rule on the separateness of that property and ruled on, at least attempted to fuss with the question of whether that had been commingled, we have a ruling from the trial court, so how can there be a preservation problem?
Then I apologize if I misunderstood. I think that my answer to that is exhibits 3 and 4, and he didn't commingle in his testimony. I think what I was trying to state was, in the brief, those facts aren't detailed in the brief by the appellant.
Okay.
And I want to clarify that I understood your answer to my question about the commingling of the separate property that was in the trust. And it's at 7332-ish in the record, which was cited to us, where Dr. Dahl testifies that at least 2 different types of stock were sold pre-divorce, converted to cash, put in an account with other cash, and then nobody tells us in that portion of the record whether that cash could still be traced or not as separate property. Are you telling me that exhibit 3 and 4 would show that that cash was still traceable as separate property?
I'm not sure that that cash was part of the 350,000, but if it was, then exhibits 3 and 4 would demonstrate that. But I think that the cash may be a separate question entirely apart from premarital tracing.
And correct me if I'm wrong, but the district court made a finding that there was no intent to commingle on behalf
Correct.
of Dr. Dahl, and that was based on the testimony that was provided at the hearing on that issue, correct?
That's correct.
Okay, and so on appeal, we are bound to defer to those findings unless they're clearly erroneous or, against the clear weight of the evidence. And so is there, other than the exhibits 3 and 4, and then the testimony of Dr. Dahl, was there any other evidence at the evidentiary hearing about the commingling?
Not that was cited by the appellant, and in our response, we brought those forward, although they were not cited. So I think that I have not seen anything to refute the judge's findings in that regard.
And my concern on that is that, yes, the court certainly made a finding that we would defer to in terms of intent to commingle, but our decision in Thorup notes that there's more than one way to get to commingling, and one is if there's an express intent.
Sure.
But the other is, intent or not, if you can no longer trace the separate property. And we don't have a finding on that. We have testimony that stocks were turned into cash, cash was dumped into a general fund, and then we don't have a finding as to whether that cash was traceable or not, which is why I continue to wonder whose burden it is.
I understand that, and I don't think there was any finding at all that the cash that's being discussed was part of the 351,000 in separate funds. Without that, whether or not the cash was, what was done with it, you'd want to know that it existed. But tracing and commingling are 2 different things. So if we knew that the cash was not part of the 350,000 in separate premarital funds, which is very unlikely to be, then the issue of the cash and an expenditure of the cash it would relate back for the benefit of both parties, I suppose, to valuing it at the date of divorce. because then there's no question of its value. Whatever was there on that date has been valued. The cash question and the other things are post-divorce. But if you value at the time of the divorce, then all those become a moot point, I suppose. Then you say, well, the value can be at the exact time of the trial. Well, Mr. Christensen had, and our brief goes through it, all the discovery to present an expert to testify on the value at the date of trial. He decided not to, and instead the expert opined on interest.
Can I move you into one more question? Your time is at
I'm
zeros,
sorry.
and I want to make sure we're focused on answering our questions at this point. On the dissipation question, the court didn't touch the dissipation question in either its original ruling or its post-trial ruling. You agree with that, right? The court just didn't say anything about it.
The court did say something, I think it's in their response to the motion to amend. And I think that might be the addendum 3 to the appellee's brief, when the court says that on the respondent's motion, I think in that one, Mr. Christensen asked for the dissipation to be addressed, and that would be at page 4. But the reason.
Where on page 4 does the court say anything about dissipation?
That's what I'm saying, it doesn't. If Mr. Christensen had brought it to the court's attention, then he would have ruled in that section.
Well,
That's
Mr.
what-
Christensen did bring it to the court's attention, both in the
Well-
in the written closing argument. It's in there. I went back and looked. And it's also in the post-trial motion, and the court didn't fuss with it either time. And so I guess I'm wondering what your theory is as to why the court didn't choose to address that argument.
Well, number one, it wasn't presented at trial. At trial, Dr. Dahl was asked one question. Do you remember a transfer of $31,000? It's in the transcript, in 2009. And I'm not sure on the date, and Dr. Dahl said, I don't recall that transfer. No checks were presented. In the closing arguments, at page 13, Mr. Christensen presents checks from Fidelity, wire transfers from Fidelity, wire transfers from Fidelity.
And so what Mr. Christensen seems to me to be doing here is he's taking some evidence that came in through Dr. Dahl's testimony and through some documents that were presented, and then he's making an argument about that evidence in closing to say, hey, these 3 transactions, I think, constitute dissipation. I guess I
don't see that evidence. It isn't in his brief, and I couldn't find it. He says it, but it wasn't presented to the trial judge. It wasn't stated to the trial judge, would you look at, do we admit these, and what do they represent?
Well, at that point, then the trial judge seems to me should say, well, I see this argument being made on page whatever of your closing argument. There's no evidence to support it, and on that basis, I reject it. But here the court says nothing. And I guess I'm trying to figure out whether that's okay.
I share that concern. I don't know if it's okay to have a trial, not present a question to a judge, not present evidence to a judge, not present a chart to a judge that says you owe me $92,391.18, and then after the trial, ask the judge to rule on it without citing to the record in the closing arguments, without citing to the record or the exhibits, and expect the judge to rule on it. I agree. I don't know any of that. I don't know why you didn't say you didn't cite, and I don't know why the citation wasn't done.
Okay. Thank you, Ms. Blakelock. We appreciate your argument. Back to you, Mr. Christensen, for 5 minutes of rebuttal.
Thank you, Your Honor. Just to answer Judge Luthie's question about the $92,000, we don't have a direct cite to the actual testimony at trial, but we do refer to it in 4 places. 3R 5953.
Before you give these, are these places that you're going to give me, are they to evidence? Are you citing evidence now, or are you citing places where you've made the argument?
I'm citing where I've made the argument.
So you're leaving to us to find where in the record the evidence is?
Well, we haven't cited it to the court in the brief, and I wasn't able to give it to the
Sure,
court.
you've had a limited amount of time. Okay.
But if you want those citations, I can give them.
I think you've given me these in the briefing.
Yes, and,
Okay.
and I would
Then
just.
we have those citations. I was wondering if you were able to, at this point to evidence.
Yeah, I am not able to do that.
Okay.
In terms of the idea of the property being turned over to Kim as essentially a settlor, I think it is akin to, I mean, if the property was, let's say, grandmother's rocking chair, she would be entitled to that rocking chair regardless of its value. If the property was 100 shares of GM stock, she would be entitled to her share of the 100 shares of GM stock, regardless of the value at the time it was turned over to her. The problem we face in this case is that, number one, that the district court did not do that, and number two, it found that it was too difficult to do that. But I don't believe that the court allowed the process to go through and didn't allow the parties to produce the evidence so
And
that the
on
court
that
could
note,
determine that.
you represented during your initial argument that you received no documents directly in response to discovery for things post-2010. And you heard the other side represent to us just the opposite, that you received thousands of documents in response directly to discovery requests after 2010. It's frustrating to me that there's such a chasm here. And you're up on rebuttal, so I'm going to just ask you one more time. Did you receive post-2010 documents in response to discovery requests?
No, but we did receive thousands of documents through the Eid-Bailey report. So, I mean, I think both representations to the court are correct, but the direct response to your question is they specifically responded to our discovery saying, you are not entitled to documents after 2010. And I mean.
That you got a bunch through Eid-Bailey?
But we did get a bunch through Eid-Bailey.
And
So,
I understand that there was a determination made that the Eid-Bailey report was not useful, but I'm not sure that that means that the documents weren't useful. If you received tens of thousands of pages of documents for post and indirect response to your discovery requests, why should we discredit the court's findings saying the available records do not allow for forensic tracing of every financial transaction that occurred, and everything that's been produced, everything that's relevant has been produced? And I know your one argument is, well, the court is viewing relevance too narrowly. But if you've received tens of thousands of pages of documents post-2010, how is it an abuse of discretion for the court to say, there's been so much happen in the intervening years, all of these documents have gone your way, it's not proportionate under Rule 26, and it's not going to be helpful? Where's the abuse of discretion there?
well, the abuse of discretion is that he didn't allow us to use those documents. I mean, I think had he allowed us to put on evidence about what happened after 2010, we could have.
The court didn't restrict you from using those. The court made its determination to use 2010 as its valuation date after you put on evidence. Isn't that correct?
No, that's not correct. The very first thing that happened when we walked into the courtroom is the court said, I'm going to rule that the valuation date is 2010. And he disallowed any testimony or production of anything after 2010 during the
Okay,
trial.
I had a misunderstanding.
Yeah, so that was the reason that we're arguing that. So my argument is we had it, we couldn't use it. We had tens of thousands of pages, but they were not all of the pages.
So, but that's a little different argument than we need more pages. Right now you're saying we needed more discovery. Now your argument, it sounds like, is a little different, which is we weren't allowed to use the discovery we had.
Yeah, you're right, but we are making both arguments.
So then please answer the question on the other argument. Why would it be an abuse of discretion to say you don't need more than the tens of thousands of pages you already have?
Because, I mean, first of all, the reason given was I don't need those documents because I'm looking at 2010, and I think that was an abuse of discretion. But the second reason is that, I mean, the court knew we had a list of, 80 things that were missing in the discovery that would help us trace or show that you couldn't trace from point A to point Z. And yes, we had lots of intervening records, but we couldn't connect all the dots without the court allowing us to get those intervening documents. So we had some of fidelity, but not all of fidelity.
Okay, thank you, Mr. Christensen. Thank you, Ms. Blakelock. We appreciate you coming down here and arguing this case for us and helping us understand this long case a little bit better today. We'll take this matter under advisement and get you a decision as soon as we're reasonably able to do so. With that, the court's in recess for today. Thank you.
Thank you, Your Honors.